Hi, welcome back to Hill and Ponton's live stream. I'm attorney Rachel Cheek, and with me today is
Attorney Allison Reddick, back
how are
again
you doing
together.
today?
I'm good, ready to answer questions with you.
All right, let's get it started. You want to take this first one?
Okay, Yolanda Frug Adams, RO erroneously closed my claims for pancreatitis and IBS without issuing decision. IBS in med records, military medical records, and pancreatitis is secondary to bulimia, stated in C&P exam. Filing to reopen as each should be given 30% ratings. Told C&P for cervical radiculopathy that also radiates down spine. Handed her NIH medical literature stating feet can cause entire spinal problems, and doctor said she was only doing neck, not looking at feet. She wasn't ortho, was internal medicine and rheumatologist. Can I ask for ortho C&P? RO also sent letters stating it was clear non-unmistakable error, that they paid me SMCS to date DOC. Chances of waiving. Now 100% permanent in total with ratings, 100% PTSD, and a lot of other ratings. How many berry bumps would that be? 6 bumps after applying for aid and attendance for PTSD.
Okay,
Okay.
got a lot of questions here. You want to start
Let's
from...
go back to the beginning. So there has to be go back to number 1. So there has to be a reason that they closed the claims for pancreatitis and IBS. It could be that you filed it on the wrong form because sometimes you'll file it on the correct form and they'll tell you it's wrong. If you've ever filed for it before, it needs to be on a supplemental claim, but you have to have new and relevant evidence. So if you didn't file any new and relevant evidence, and that could be a statement of you saying, you know, I have records of IBS in my military medical records, and in this C&P exam, it stated my pancreatitis is secondary to my bulimia. Were you even afforded a C&P exam? You can ask for a C&P exam, but you've got to figure out why they closed it. If you have a VSO or an attorney representing you, they can go in your claims history in BBMS and look to see why it was closed. They can go in and look at the closed claims. That's how I figure out why, if something hasn't received a decision, or if you received some kind of correspondence. So you got to figure out why they closed it. Okay.
And you can ask why, like you should at least be able to, if you don't have a VSO, I would try, I don't know that they would, but you could try to call VA and just say, hey, why were these closed? Also consider that VA lumps a lot of conditions together. So for, I believe it was pancreatitis and IBS, if you've claimed anything like, I don't know, claimed like a colon condition or chronic diarrhea or something, they're going to count that. They're going to say IBS is the same as that. So what it may be is that you didn't claim these exact conditions, but something kind of similar, and RO's lumping them together. Another way that you can constitute a supplemental claim for new and relevant evidence is if you are claiming something under a different theory of service connection. So for example, say you asked for pancreatitis second to exposure. Not saying you did, but say that's what was claimed. Here, the evidence is going to be, yeah, you guys looked at exposure, but you didn't look at secondary service connection. It's secondary to a condition I already am connected for. So that could also be something you might need to specify that you're asking it under a different way to get service connected. Number 2.
That would also be a way for your new and relevant evidence. So even if they lumped it in with something else, you file a supplemental claim and you say, I'm claiming that, like file a statement as your new and relevant evidence saying, I'm claiming an alternative theory of entitlement. I'm not, before I claim toxic exposure, now I'm claiming it secondary to the service-connected bulimia or something like that. So you need that new and relevant evidence to reopen it. Okay, go ahead.
This next one I believe is about, spoke about, there was the theory was that problems in your feet could cause issues in your spine. And then it sounds like this provider wasn't super qualified, because if it's not, now if you have rheumatoid arthritis, obviously that is the correct examiner. You have to see for rheumatology. But if it's something like degenerative disc disease or anything that's not, immune related, I would definitely want someone who's a little more qualified. Although I could see VA saying, well, they did our training.
Yeah, I don't think that they're going to give you a new exam if you ask for an ortho exam. You can try. I don't think they're going to do it. I think you need to get a medical opinion or something from your doctor saying that the feet condition, the service connected feet condition, led to issues with your gait, which led to issues with the spine. You can try to ask for ortho CMP exam. I don't think they're going to give it to you. And then SMCS, I see Q for SMCS all the time. Sometimes they'll ask for recoupment of that money. Sometimes they won't. If they do, you can ask for a waiver and give financial information. It's hit or miss. Sometimes I see that they'll grant the waiver and sometimes they won't. I don't really have any advice on that. Do you?
No, just give the information you can. If it's their fault that they overpaid you, then they shouldn't ask for it. I do see people who get hit with overpayments. Generally speaking, if you reply with a request for a waiver, it can be drawn out.
Especially since it's SMCS is an ancillary benefit that you're specifically not asking for. So you didn't do anything to cause that error. So I would specify that in my waiver request. This is an ancillary benefit. This is an extra benefit that I didn't ask for. VA gave this to me. And how am I supposed to know I wasn't supposed to be receiving it? So it should be waived.
And then the final question was regarding the berry bumps, which is just as a refresher, obviously Yolanda knows this. If you have special monthly compensation L for aid and attendance for one condition, or it can be more than one condition, but they have to be specified. You've got to have it for certain conditions. And so here, Yolanda's got 100% PTSD, tying aid and attendance into that. Great. If you've got that and you have additional service connecting conditions that are either rated 100% by themselves or 50% either by themselves or combined with other conditions that are not considered in your aid and attendance grant, you can get bumps in special monthly compensation. However, without knowing what these ratings are for, I need to see your rating sheet to tell you, because I see the ratings, obviously 70, 50, 50, that's half step, half step, half step, 1.5 right there. We could combine all these little ones, but it's really going to depend what those are rated for. Certain things they're going to combine and certain things they're not. So
it depends on what you're claiming for aid and attendance, because you have to remember what you're using for aid and attendance, you can't use for the additional bumps. So if one of those is like, I don't even know what the 50s would be. Like migraines, and you put that on your aid and attendance form, you can't use it for an additional half step. So it really depends on what you put on your aid and attendance. Well, it says they're applying for aid and attendance for PTSD. So it is hard to get aid and attendance for PTSD. And if you do get it, then that can bring up issues with incompetency, where they may say that you're incompetent, but like we've discussed in past lives, if you're able to manage your finances, you can get your doctor to write a letter, but that still is just a red flag raised when you do aid and attendance for PTSD. But like Rachel said, it depends on what those ratings are for, because like she said, they can be lumped together.
Yep. Next question. All right. Kilo 9 Bravo Bravo. Hi, if a 65-plus-year-old veteran recently rated 100% permanent in total, but has a recently submitted board appeal for obstructive sleep apnea pending, would you recommend letting the sleep apnea appeal ride or cancel it? Thanks. Oh, don't cancel it. I never want to withdraw a board appeal because you never know. They might grant it. If they don't, then great, you're permanent and total, you're fine. It's not going to change anything. But if they do grant it, just like we were talking with special monthly compensation a question ago, that can play into, if you've got an additional 50% rating, that can play into an attendance. It can play into SMCS. I don't cancel it. See what happens.
I would also say it depends. Are you claiming service connection for sleep apnea, or are you trying to get a higher rating? Because I think that would affect, I don't know. I agree with Rachel. I wouldn't withdraw it,
They're
but
not
like
going to take benefits away.
it's not going to affect any of your current benefits unless it's a rating issue, because what if they drop your rating for
The board
sleep
won't drop their
apnea?
rating.
I know, but if they remand it back down, if it's
I
but if it's service connection, I would leave it. I would also seek counsel. Okay, another step. I am service connected for my shoulder injury and surgery. I have started experiencing back and neck pain. I do not have a specific diagnosis, but appointment scheduled to discuss with a doctor. Are there presumptive conditions that can be secondary to my existing shoulder injury? What should I be looking for to maximize my claim? Okay, well, first, you need a diagnosis. So having appointments for your ortho or for your primary care is most important, because first step is having a diagnosis. I don't think presumptive would be the word. I think it would be more or less inferred, whether there are issues that would be inferred secondary to a shoulder injury. Not that I can think of, but if you go to your doctor and your doctor says that you have back issues and it's due to your shoulder, then absolutely you can file a claim for a back condition secondary to the shoulder, but you would need a medical opinion for that. So there's not anything where they're going to say it's secondary to. The only inferred issue I would think would be radiculopathy. That's an inferred issue where, due to the limitation in your shoulder and the injury, it's affecting the nerves, and the doctor says that you have radiculopathy. That's a potentially inferred issue, but you still need to file a claim for it, and you need a diagnosis for it. What was the other issue that they said? It was back and something else. Back and neck. So first you would need diagnoses of the back and neck condition. Also see if you have radiculopathy of the shoulder. Anything else you think, Rachel?
I would think the neck honestly sounds like I could see that being pretty like common sense related to the shoulder. As Allison says, you do need diagnoses. But noting now that you have this pain recurring, you're experiencing issues, make note of that. You can even file a claim now. Again, they're not going to grant it until you have that diagnosis. But something you can ask your doctor about when you go to see, we are not doctors, we are just lawyers, is if you notice you maybe, take on more with your uninjured shoulder. You tend to maybe lean to the side to kind of favor your other one. Think about like the way that you move and the way that your shoulder injury affects your daily life, and make sure that your doctor knows that. Something else, it's again, would not be inferred, you'd have to claim it, but something that we often see with clients who have issues with just, one shoulder, over time, you using one to compensate for the work of two, you're going to damage that uninjured shoulder over time. So that's something, think about, do you have pain in your uninjured arm? Radiculopathy is another thing that can come with either the shoulder directly because of surgery, or if they do end up connecting your neck, that could cause it. The other issue with your currently service-connected shoulder that could be considered, and this would go along with radiculopathy, is loss of use. So if since your shoulder surgery, this would be an extreme example, I hope you don't have it, but you've got this nerve pain, it's so weak, you're not able to really use this hand for anything. You're not able to grip objects or pick things up. You can't like use your fingers to manipulate an object easily, things like that. You could be looking at loss of use, but that's definitely something that you want to get on the record and established. But yeah, consider basically your uninjured side. Do you notice symptoms in it now that you didn't notice? You didn't injure it originally, but now are you noticing problems after years of compensating? That's a big one.
I would also file an intent to file rather than a claim, since you don't have a diagnosis yet. Intent to file will give you a year to protect that effective date.
That's a great
And then
point.
once you get the diagnosis, then you can file the claims.
Right. The Veterans Aid. My PCP completed an aid attendance exam form stating that I need aid attendance for my mental health due to forgetfulness, medication management, food prep, etc. Is there any harm in submitting the form if I have appeals pending? If granted aid attendance, what would my SMC level be? 50% for sleep apnea, 50% for migraine, 40 lumbar, 30 shoulder, 10 for hypertension. Okay. A lot of 10s. And then can we go back to number 1, please? I am going to guess that you are service connected already for mental health. That sounds kind of dumb. I know you just mentioned that's why you need aid attendance, but it wasn't listed in the number 2 here. Let me see that, please. Question 2.
Part 2.
Part 2. In any case, I did not see it listed on the conditions. So thank you. I'm going to guess that you are service connected for it. Putting aside what me and Allison are both going to say as far as proving aid attendance, which would be step 1,
But first, pause. If you're not service connected for PTSD, don't file it.
Well, yeah.
Don't file. That's number 1.
That's number 1. Yes, you've got to get service connected for the underlying condition. If you have claims that are already pending for, say, higher rating or conditions that are not related, that's fine. It's just another issue that you're raising. I don't know now. I'm scared to answer the SMC level because I'm not sure what the mental health rating is. Allison, any thoughts here?
I think it depends on, well, it's not going to hurt your other claims if you file it. It's not going to affect them. It depends on if you have 100% rating for mental health or you have 70% with IU for mental health, because that's going to make your claim more likely to be successful than if it's a lower rating, because for some reason the regional office thinks that you have to have IU or 100% rating to have aid in attendance, but you don't. So if you do have it 100% or IU based on the 70% rating and the other issues for IU, that'll make it easier for the aid in attendance. But I think generally filing it isn't going to hurt your other claims, as long as you're service connected for it. If you're not service connected for it, they're just going to reject it and say, you're not service connected for this issue.
And as far as guessing SMC, saying you got 100, we'll just say, you get aid attendance for your service connected mental health alone, 50% sleep apnea. Now it depends though, because are these due to these conditions? Some of them, sometimes if they're tied up with PTSD, which I know often, or mental health, which I know sleep apnea and migraines often can be, they might not consider that. I would argue that they would be separate because they're different body systems. So I would say you need at least one half with the 50, another half with the 50 migraines. So that's SMCM, 40% lumbar plus one of these 10% down here. I feel like I'm doing like magic. I cannot actually do all this math in my head. I'm going to go ahead and point everyone to the rating calculator that we use, our combined rating calculator on Hill & Ponton's website. It is very helpful. I do use it a lot. I'd have to write all this down and do actual math, but I would say you'd be looking at least 1.5 extra steps, probably more with that 30.
At least 1.5 based off of this. TWSR. Okay, in August 7th, 2023, 526 EZ, intent to file. That's confusing. August 6, 2024, filed a completed application. Okay, so that was within a year. August 18th, 2025, VA rates me 70%, issues back pay check 23 months, not 35 per PACT Act. Did they get it wrong? Probably. The intent to file isn't a 526. A 526 is the new claim. But if you did file an intent to file on August 7th, 2023, and the new claim was on August 6th, 2024, that's within a year. So maybe they just either they didn't see the intent to file, or you filed another claim prior to that August 6th, 2024, because you can only use the intent to file once. So see if you filed any other claims prior to that. If not, I would just file a higher level review and say, there's an intent to file from August 7th, 2023. I filed my claim within a year of that on August 6th, 2024. I am entitled to an effective date back to the intent to file date.
You know what's confusing me here is I'm not, because of the 3 dates, and we're talking about 2 different documents, so it's hard to say. Do you see what I mean? There's 8/7/23, there's 8/6/24, and there's 8/5.
Oh, you're right.
8/18. I think 8/18/25 is when the rating decision was made. I'm not sure.
Wait, so it seems like, okay, hold on. Yeah, I'm confused. You're right.
Because
No. The last one, the 8/7/8/18/25 is when the decision was made.
okay, they did rate you, and okay,
yeah, so that's what it is. It's all because it's in August. That's what it was confusing.
Yeah, so
But
like,
no.
that's a year apart.
It should be a valid intent to file. It should go back to that date unless you filed another claim prior to that. It should go back to the August 7th, 2023. I would file a higher level review.
And I would also say, going to August 7th, 2023, what the issue is, they want it to go back to August 2022, the date of the PACT Act, which I believe it's August 10th, 2022, right? That you had to file it within just under a year.
Yes.
So I would point that out. I would be specific that you want to go to 8/10/2022 based on the PACT Act because you did your intent to file, lay it out just like you did. Maybe.
But it has to be issues that are associated with the PACT Act. It can't be like a mental health claim.
Yeah, that's a great point.
Like that.
Yes.
If it's not something that the PACT Act introduced, one of their presumptive conditions or anything associated with that, then it's not going to go back that far. So like if it was hypertension, or if it was asthma, or a certain kind of cancer that PACT Act brought up, something like that can go back to that date. GI issues, things like that. But if it's like mental health or migraines or sleep apnea, like those aren't going to go back to the PACT Act date. Those are only going to go back to the date of the intent to file.
Michael, I received favorable findings that I required in attendance, but I was denied any SMC stating not regular. What is regular exactly? I have incapacitating IBDS. Yep. Okay. Regular. So the specific requirement for aid in attendance, the way it's written out, is due to service-connected conditions, you require the regular aid in attendance of another person. Regular is not constant. It's not even daily. When I talk to clients and I try to explain this, or, get a picture of the disability, that's, regular is every other day, 3 times a week, depending what the issues are, maybe a couple times a week. Recurring. You have incapacitating IBDS. So you're not like, I'm sure you have more incapacitating episodes than others, but you're probably not jumping out of bed and getting easily around on a good day, right? What I would want to do to make sure that VA knows is you really need to specify how often this care is needed. Go like a regular week. I need help getting in and out of the shower every time I take a shower. That's every day. When I leave the house, which is a couple times a week, I need help bending over. I can't bend over and put on my shoes and socks, so I need help with that. I need help getting dressed every day. Things like that. Just you really want to establish how often they're occurring and how regular it is. And what really will help is a statement from whoever helps you. If you have someone assist you with these activities, that will really help. Or maybe someone who they're not there in person to do the activities, but they are aware of what you do need help with. Say a friend or family member you talk to on the phone, they don't live close by, but they're familiar with your situation and your needs. So I would definitely want to do statements to really show the regularity, and any appeal that you file, I would do supplemental and point out, they denied me because they said it's not regular. Please see the attached statements. I need this help multiple times per week, every week.
It's so interesting how different, because I would go a different route. It depends on what the decision says. I would want to read it first, because sometimes they'll deny it because they'll say non-service connected conditions are adding to it, whatever. But if this is just a situation where you have a favorable finding where it says you need aid and attendance and the denial was because it's not regular, I would file a higher level review and I would have an informal conference and I would ask what regular is, because I really like higher level review. It is hit or miss. It's like 50-50. But if I can get someone higher up to have a conversation with me and tell me what I'm missing, or they'll grant it. Whereas when you go back in supplemental, kind of you're back to the bottom tier reviewing your decisions, and they may not even look at the statements and you may have to go higher level anyways. But that's what I would do. I think either way you can get to where you need, because let's say we go Rachel's way and you file the statements and they still deny it, then I would go higher level and say, look at these statements. This proves regular. But sometimes you can skip that step with the initial higher level. It's kind of a round and round circus, but I think eventually you'll get to where you need to go at the regional office. If you go through supplemental higher level, higher level, then at that point I would go up to the board. But yeah, I have not seen a denial based on regular. So that seems very bizarre. And so I would do higher level because I've never seen it before and see what they would say. Usually it's because of like non-service connected conditions. I'll often see them give favorable findings for aid and attendance and still deny it because of like I said, non-service connected conditions. But in this case, if there are no non-service connected conditions that are affecting it and they're just saying it's regular, that is very arbitrary, and you may get a good decision review officer who will just grant it for you. So multiple ways you could go about it, but eventually you should be able to get it. Navari Nye. Have veteran whose toxic exposure is conceded in her claim letter. The VA keeps refusing to treat her because she makes too much Social Security and retirement pay. The patient advocate has been no help. Shouldn't she get free health care because of the PACT Act? Her husband is retired E6 with 90% disability. I don't know.
Go to number 1, please. Have a veteran. So the veteran, it sounds to me like the veteran is married to another veteran. Mm-hmm. That sounds right?
Yes. If usually you have to have something service connected to be able to get treatment at VA. So if there's nothing service connected,
that is probably what it is. Her toxic exposure might be conceded, but what needs to happen is a claim for the disabilities caused by that exposure. So they might say, for example, if she served in like the Persian Gulf area, they might say, we concede you're exposed to particulate matter in burn pits, but you've got to actually have the condition that comes from that. So digestive issues, respiratory issues, anything like that. Definitely, it sounds like, yeah, she should probably be service connected. And then as far as if she's a veteran herself, it doesn't matter as much, but just for information. If you can go to number 2, please. Husband is a retired veteran with 90% disability. I know once you're at 100% or IU and permanent and total, your spouse, regardless of veteran status, does get included with your health care. They're not always at the VA.
Champ VA.
Eligible for Champ VA. So yeah, she's got to have a service-connected condition, I do believe.
Or the spouse has 100% or TDIU permanent and total. Easy issues, usually tinnitus. That's something that you can get service connected and then get treatment at VA. But yeah, claims need to be filed that are due to the toxic exposure and then service connection.
Yeah, tinnitus, respiratory issues, GI issues. I'm thinking if they were maybe in the Persian Gulf War with the toxic exposure, things like that, definitely take a look at claiming. Michael, hello. How do I prove loss of use of my legs? My 2680 already says I'm bed bound up to 3 months. This is Michael, I believe, that had the question about the in attendance and whether it was regular or not. So now I'm wondering, you know what? Sorry, this is your earlier question I'm answering, but I bet what happened is VA saw like bed bound 3 months and you're like, oh, well, there's 9 months that you're not bed bound, so it's not regular. So again, back to what we said, we need to make sure that regular is established, that it's not just these 3 months. You prove loss of use of your legs. The criteria that you have to show is that there is no remaining effective function in your feet or legs other than that which would be equally served by a suitable prosthesis.
And the way that's determined is your ability to maintain balance and propel yourself forward.
Yes, like taking a step, can you like push yourself off the ground? So for that, obviously you've got to be service connected for the this maybe comes from your IBDS, I suppose.
And then radiculopathy probably from.
Yes. So what you want to do is this is something I think where you do need to get new evidence. If it's not already on file, it may already be. If you are wheelchair bound, I mean, that's pretty clearly shows like, okay, you can't balance or propel. Either you don't have the strength, you don't have the balance, your feet aren't reliable. Or
lots of falls,
documented falls. If you find yourself like, well, I don't have falls, but I do need someone to help me get down the stairs and I have to hold on to furniture and walls to keep my balance, that's not normal functioning. That's something like you're making up for your inability to balance with your upper body. So that doesn't mean your legs are functional. If you use a walker, if you've been diagnosed or with foot drop, or you tend to drag your foot,
Usually it's not something that they're just going to give you. You have to file a claim for it. So you would want to file a new claim for loss of use of the bilateral lower extremities. And if it is through your radiculopathy, what they would do is they would do new examinations to see the severity of it and whether you do have that lack of propulsion and inability to maintain balance. If you're wheelchair bound, that's going to make it easier. But like Rachel said, most likely you're going to need additional evidence from your provider saying that you have diagnosed foot drop, which is a big one, or that because of the limitations from your service connected lower extremity conditions, you're unable to maintain your balance and you have loss of use.
It is pretty hard to get granted, at least I know at the regional office. A lot of times the CMP examiners, the question is worded such that it sounds like they're saying, should the veteran have an amputation? Do you recommend that he has an amputation and a suitable prosthetic? That's not what's being asked, but a lot of times that's what the examiners read because it says, is the function equal?
They're not going to go out and amputate people for prosthetics. prosthetics.
Yes, even if you do have foot drop, no one's arguing, oh, well, you should get that amputated.
Yeah.
That's not the question. The question is the function the same? As if you had, say, if you had a prosthetic foot, that's at least going to be able to balance, right? So you may find yourself being denied initially, probably will. But if you've got, I think you said your PCP filled out another 2680, or that might have been another person. I would see if your doctor can help you out as far as describing propulsion and balance deficits due to, and they need to specify what condition it is, and try it out. You might have to go to the board for that. Often we do.
TWSR. Does it take longer for the VBA to decide on 218940 than a 26EZ application? I don't know. Technically they're kind of the same thing. Not really. An 8940 isn't its own claim, but when they put it in, they say that it takes 125 days, I think, to make a decision on things. But I don't see one being decided earlier than others. The only thing I could think of is for 8940, they're inclined to deny. So maybe that is easier, where someone gets it in their queue and they just continue the current ratings and deny IU without doing examinations or anything. That may be a way. It will be quicker. Usually they should do exams. But if they don't, then maybe 8940 is faster. 526 easy. It depends on the condition. Depends on if you need toxic exposure risk assessment, a TERA analysis. Depends on if they're going to give you examinations. But I personally haven't seen one be faster than the other. Have you, Rachel?
It's hard to say. The thing with the 8940, the application for IU, is that whatever conditions you list on that, VA is going to take it as a claim for increased rating for those conditions that are already service connected. So sometimes I do see IU claims taking a while because, the veteran may have 6 different conditions listed as what causes them to need IU. Then VA's got to do 6. They usually, I think, will do like 6 different exams unless they've done it recently or there's, evidence showing otherwise. But it really depends. I'd say depends how many conditions you listed on your 8940, really.
It depends on how many conditions you list on the 526 EZ.
That's a good point.
If you list 10 conditions on there, it's going to take longer versus 1. But we don't really have
as a rule. There's not one. Jake Gardner asks, is lumbar radiculopathy the same as lower extremity neuropathy, sciatica, and peripheral neuropathy, I'm guessing, bilateral? Lumbar radiculopathy, what?
No.
Well, the sciatica and lumbar radiculopathy a lot of times are the same. But okay. Allison, take it away.
Lumbar radiculopathy starts from your back, and it affects the nerves in your back and go down your leg and can go down into the foot. Peripheral neuropathy starts in the feet, in the hands, and it goes up towards the body. So they're 2 different conditions. The sciatic and the femoral, those are the same because it's the same nerves being affected. It's just where in the leg they're being affected. So radiculopathy starts at the base of your body and goes down, whereas peripheral neuropathy starts at the extremity and goes up.
Yes, that's easy to remember, radiating and periphery. But I think the question here, sciatica also you will see as a diagnosis sometimes for radiculopathy. I think what you're asking too is that are they rated the same? And yes, they can be. So a lot of times I've seen veterans who are service connected, say for peripheral neuropathy related to diabetes. Even though they are different conditions or different diagnoses, the same nerves are going to be rated. So either your sciatic nerve, or you can have both your sciatic and your femoral nerve rated. Those are the two main ones in your legs. That can be affected by peripheral neuropathy, but then, and you can be service connected, but then say you also have a claim going for service connection for your back, you've got the radiculopathy, and they note that, you're not going to get a rating for lumbar radiculopathy sciatic nerve and peripheral neuropathy sciatic nerve. They're going to put them together. You're not going to get the same nerve rated twice, but what they should do is rate you based on the most severe. Say your lumbar radiculopathy is worse on your sciatic nerve than the peripheral neuropathy is alone. They will usually combine them, even if you have those two separate diagnoses.
Since it's affecting one nerve, you can't get both. So like I have a case right now where the vet is service connected for peripheral neuropathy, but he also has a claim pending for radiculopathy because his back is connected. But they want to sever his peripheral neuropathy because they're saying he wasn't exposed to Agent Orange. So I'm like, well, let's wait to see what happens with the radiculopathy and see if those ratings are similar to the peripheral neuropathy, because they're not going to give you both. I mean, they can give you both, but you're not going to get rated twice. Like Rachel said, they're going to be combined. So you can have femoral radiculopathy and peripheral neuropathy, and you can have sciatic radiculopathy and peripheral neuropathy. Like both of those are one rating for each side, or you can just have radiculopathy or peripheral neuropathy. You're not going to get additional ratings if you have both conditions. It's just whichever is most severe.
It's kind of like, if you guys are probably familiar, if you've ever seen the YouTube, like, that mental health conditions are rated together. It can be anxiety and PTSD and general anxiety disorder and schizoaffective disorder. I've seen veterans with like 6 different lists, but it's all the same rating.
Or like respiratory conditions. That may be a better example, in that you have sleep apnea and you have asthma. Your asthma is only rated 40%, but your sleep apnea is rated 50%. They're going to give you whichever one's higher. So they're going to give you a 50% rating for your sleep apnea and asthma, because you can only get one respiratory rating, but they're going to give you whichever one is going to give you the higher rating.
That's right. So our next question.
Mitch A. Monroe. Hello. I was diagnosed with hypertension during my exit exam for the Navy. Shouldn't this be considered as service related? And I did not have it when I entered. Yeah, probably it should be. I would make sure you don't have any. The only thing I could potentially think of would be like family history. They can try to say, but if it was diagnosed during service and it's your active duty service, it can't be like diagnosed on a reserve exit examination. It has to be active duty. Then yes, I would think it should be service connected.
Agreed. Yeah, make sure you file a claim for it. One other thing I have sometimes seen them say is like, oh, just one elevated blood pressure, white coat syndrome. But if it sounds like it wasn't like they just had elevated blood pressure. They diagnosed you with hypertension. That means a pattern of increased blood pressure ratings. File that claim. TWSR says, ooh, that's a good question. Is one who is separated but still legally married entitled to additional spouse benefit payments? Allison's nodding hard. Give us this answer.
Yes, I have so many clients who are still married, and I'm like, get divorced because they're going to. Well, if you want to, reconcile if you can, but in the situations where you can't, that money, they're entitled to it until you are legally divorced. So I have many veterans who are giving dependent benefits to their spouses because either they haven't gotten divorced yet or it's a difficult proceedings. But yes, regardless of if you're separated, as long as you're legally married, your spouse is entitled to those dependent benefits. Yes. And they'll send it to them like separately. I had one veteran who was incarcerated, and they continued to send the spouse the benefits at the separate address. So if the spouse goes in and says, yeah, we're separated, we're still married, this is my new address, they'll continue to send them if they update the information, then they'll continue to send it to them and separate it out. Michael, I filed Q claims motions under Chisholm v. Collins, but the VA AOJ told me to file them in a supplemental claim, which is wrong. I submitted via quick submit. What should I do? There's no
Welcome to the club.
there's no correct form to file a Q claim. I've been lucky in filing it on a 526 and they've accepted it. You just have to keep trying on different forms until you get them to accept it, or tell them, like, if you're not going to accept it, to give you appellate rights. Rachel, what has your experience been?
The same as Michael's, which is that now we just default to supplemental claim. It's not right. There is no prescribed form. Argue about that after they make the decision. But go ahead. What we do is if VA is like, hey, it's the wrong form, like, okay, fine, here's this form. If they're arguably right. We usually do it on a supplemental one, because think about it. You're raising an issue that's already been decided. So I could see through VA's eyes. That's why it's a supplemental form. Go ahead and file it. And then once it's decided, you can argue about, hey, there's no correct form. It should go back earlier. Although if it's a Q, it doesn't really matter. Filed supplemental.
Yeah, file supplemental.
You can have 2 more questions. Oh, 3-parter for one of them. Modi 11 says, where do I find my actual cumulative rating? I'm currently rated 80%. I'm 20% bilateral AC joint, so it's 20%. 20% IBDS, 20% each, I hope, for your left and right radiculopathy, 20% each, I hope, for your left and right sciatic radiculopathy. Should bilateral calculation be included for both sides of radiculopathy? What claim information is available for those who served in Panama and Fort McClellan? Whoa, through curveballs here. Okay. Favorable findings on my denied claim for secondary knee and hip to IBDS. It states I have a confirmed disability for knee, hip, osteoarthritis, bilateral. What do I do next? All right. Thank you. Yes, bilateral calculation the bilateral factor should be included in both. Any of your conditions that affect one side, like, what is it called? Paired organs? Paired limbs, Allison?
Paired, yeah. Paired. But the initial question was, where does she get her combined rating?
It should be on your actual rating sheet, which should accompany your most recent rating decision.
Or
now we have, what's that?
You can go on our website and use our calculator and calculate it, and make sure for your paired limbs or organs that you are clicking those to get that bilateral factor added in. In the comments, you can see where to access that calculator. I use that calculator every single day, because even though your combined rating is on your rating sheet, that calculator gives you your calculated combined rating. So if you're 90%, it can show whether you're 86%, which is really far away from 100, or if you're at 93, where you only need 20 more percent to get to 100. So check out that calculator, and then go back to the second part 2. Oh, claim information for Panama and Fort McClellan. We have a ton of information for Fort McClellan on our website. I don't really know too much about Panama. Do you know anything about Panama?
I don't.
I had a vet who was service connected for Agent Orange exposure in Panama, and then it was severed because there's not a ton of information there, that they aren't conceding that Agent Orange was there. But absolutely, we have a ton for Fort McClellan. Lots of toxic exposure at Fort McClellan that, as we move on in time, VA has become acknowledging more, but it's still a fight. And then part 3.
What's next after? Okay, so you have your conceded disability. So you don't have to prove that you have it. They've conceded the diagnosis for your knees and your hips. What probably they said was lacking, they probably said there's no nexus between the IVDS and the knee and the hip. So most likely what you're going to need is a medical nexus. So either, preferably your treating provider can document. Either could be, how do you do back How would you do this, Allison?
I've always heard that ortho issues affect from the ground up. So your feet and your knees and your hips can affect your back. I could see an argument of how your back can affect your hip, but I don't know about the knee. That would be something, but if your doctor says it does, then you just need a nexus opinion from them. I don't know the medical
Well,
background.
do you have a limp from the radiculopathy? That could be something. Can you go back to part 1, please, of that question?
Yeah, like if you have radiculopathy and one side is more excessive than I guess they're equal, but like, let's say regardless of the rating given, if one side is more effective and you favor one side more than the other, and then that could create a knee condition. Absolutely. If you include the radiculopathy in, that would be a way to do it, which would also affect the hips, but ortho is hard and you need a medical opinion most likely.
I know a lot of times I will see the hips claimed with the back, and then it's actually related to the radiculopathy. But that's a pretty common relation, so they should have looked at that. But do medical opinion or see if you can get a nexus letter from your provider. And just like kind of think about your history, like before you do that, just like we're talking, like, do you have a limp? Did you, have you noticed over time, like you favor one side or the other? Did you ever, I don't know, fall due to the back condition? Like you're bent over, you can't see where you're going. Did you fall? Did you ever hurt? I don't know. There's lots of ways to go without seeing a specific.
You fell and you injured your hip or your knee. Yeah, because of the back.
I'm guessing not, because they said it was just arthritis, but that is a great point for people to keep in mind. Even if something happened after service, if it happened due to a service-connected condition, you can still be service-connected. So an example, as a client I'm thinking of, is service-connected for seizures. He had one when he was driving. He drove his car off the road and ended up with orthopedic injuries. That's service-connected, because if not for that seizure, that wouldn't have happened. But yes, best of luck with that. And then
last question.
Yeah.
St. Andrews, I'm a Gulf War vet. I'm service connected 30% for IBS associated with Tara. If I file for fibromyalgia, how can I avoid them combining the two ratings if one of the symptoms of fibromyalgia is IBS? They won't combine the two ratings. They just won't give you additional, like they'll only associate, I don't know. They're not going to combine them. I've seen people with IBS and fibromyalgia. The way fibromyalgia is rated isn't based, like, even though some IBS can be a symptom of it, it's based on the number of, what's the word I'm looking for?
Pain points?
Not like
tender.
Like, no, like when you have like a flare up. I'm pretty sure that's how it's rated. Let me look. But you'll definitely get separate ratings for them. I wouldn't worry about them being.
Yes.
So it's episodic. Well, first 10% is if it requires medication, requires for control. Then exacerbation, that was the word I was looking for. Where you have widespread musculoskeletal pain and tender points with or without fatigue, sleep disturbances, stiffness, paresthesia, headache, IBS, depression, anxiety. And so it depends on whether you have episodic or constant exacerbations. So the fact that it says with or without IBS means that that's just one symptom of it, and it isn't necessary to have fibromyalgia. It's just one of the potential symptoms. So you can have two separate ratings for the IBS and the fibromyalgia. So since you're Gulf War, it's the hardest part in that is getting a diagnosis. If you have the diagnosis, then that should be presumptive and you'll receive ratings for both. So don't worry about pyramiding or anything for that.
No, and keep in mind too, all those conditions Allison listed, with or without headaches, IBS. Now I can't remember what the rest of them were. There are many different manifestations of fibromyalgia. If you have symptoms, other than IBS, headaches or whichever else that are common symptoms, keep in mind that if they're due to fibromyalgia, you are supposed to be rated for those. they would be rated separately because, for example, headaches, that's not rated under the same exacerbation criteria as fibromyalgia. If you have an
Depression,
underlying
anxiety, those should be rated
common,
separately.
yes.
Yeah. Mm-hmm.
So that's just something to keep in mind for any condition that can cause a lot of different multi-system symptoms, like fibromyalgia. A lot of times you talk about Parkinson's. I know there's also like what other things affect many different systems.
Multiple sclerosis.
Multiple sclerosis, just the one rating for the underlying condition is great, but they also need to rate you for the separate manifestations, because for that fibromyalgia does not consider rating, won't consider headaches, just like it doesn't consider IBS in the rating. So that's something to keep in mind if you have a claim or are rated for an underlying big condition like that. Always take a look and make sure you're getting rated for the symptoms that are caused by it as well. All right.
That's all the time we have for today. I hope we answered your questions. And if you have any further questions or ideas for videos you would like us to make, you can put them in the comments. Please like and subscribe, and we appreciate all of your service. Or if you are a family member or service member, thank you very much. We love what we do. We are here to help you in any way we can. And thanks, Rachel.
It's a pleasure as always, Allison.